All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Blasier, Mr. Neufeld, Mr. Snyder Chapman, people represented by Ms. Clark, Mr. Darden, and Mr. Gordon. The jury is not present. Counsel, yesterday I stayed in the courthouse till after 6, and Mrs. Robertson was here well after 7. And we did not receive the materials, and apparently you've given the materials to Mrs. Robertson this morning, correct?
Well, before I left, you recall, I came back and indicated that you'd have it first thing tomorrow morning. I didn't come back and tell you that before we left. It was my understanding that I told you that...
My recollection is Mrs. Robertson and I were waiting. But
my understanding was I came back
Counsel, the point being is that that's another evening that I didn't have to work on these materials.
You understand? Judge, let me address this.
No, Counsel, all I'm pointing out to you
Yes.
is this. What you have presented to me with regards to these tapes and transcripts is a very prodigious task.
You just don't know how prodigious, Your Honor.
Oh.
And that's why I wanted...
I know.
No, you do not know. You do not know. Let me tell... May I just say something for the
No,
record?
Counsel, the only point I'm making is that given the volume of the materials that I have before me, you should not anticipate a ruling on this issue this week.
We
That's
don't,
the
Your
point
Honor.
I'm making.
Let me just say this. We try to be reasonable. Judge,
I understand that.
I had to stop my entire office. I've had 3 secretaries for over a week working around the clock. In addition to that, Judge, I mean, I have a flourishing law practice. I had to stop them to do this. In addition to that, we're also cleaning up tapes. We have now, so that because of Your Honor's ruling, which we take some exception to yesterday, your memo, that we have now keyed in our tapes with the proffer, along with her tapes, which weren't verbatim. In addition to that, there were some tapes she had not transcribed. There are now 10 additional N-word references. There are 40 instead of 30.
Mr. Cochran, I'm going to cut you off right there.
Okay.
The only point I'm making is that I have a lot on my plate right now.
I understand that,
You're
Your
not going to get a ruling on this until sometime next week. That's my point.
Okay, and I have no problem with that, Your Honor, and I
All right, so
understand that.
plan your witnesses accordingly.
It's a lot of work, and I understand that. We are, and I understand, well, I don't know if we have any dark days or all this week, but at any rate, we will be prepared. We're prepared to deal with that.
All right.
We are prepared today. And may I just indicate to the court what we expect and what we need to do today at this point? I have present today Dr. Christian Reichardt, and I would like to do a 402 motion regarding his testimony. We have Detective Ken Berris. We flew in from Chicago. I want to do a 402 regarding him. Mr. Howard Weitzman will be here at 10:30. I want to make sure there's a 402 regarding Mr. Weitzman. Sean Chapman is here today to argue the Menzione matter. We want to argue, tell the court what we have before I bring her out here for Thursday. So we'll save some time. We're flying witnesses in and out. We're very aware of that. And of course, Dr. Henry Lee is in the wings.
Before you get further down the path, once you approach, let me just chat with you off the record.
All right.
All right, thank you, counsel.
There's one other matter. We would like to recall Mr. Larry Reichardt to the stand, Your Honor, for the following purposes, and I can make an offer of proof if the court would.
I was wondering why Mr. Regal is still here.
Right, because we want to, Mr. Blasier would like to recall him to the stand. And I'd like to make an offer of proof if the court would care to hear it.
No, Mr. Goldberg is not present.
Okay, I'm sorry.
So
Is he available?
We will call for him.
All right, let's have Mr. Regal down. Why don't we proceed to the, you wanted to have a 402. I take it this is in the form actually of an in limine motion to restrict certain cross-examination of Dr. Reichardt? Is that what?
Yes, Your Honor, it certainly is.
All right, why don't we do that since we have all of,
All right.
my recollection is Mr. Darden was the attorney on the prosecution side who was going to be conducting the cross-examination of Dr. Reichardt. Is that correct?
That's true.
Okay,
So we're going to have a motion in limine on cross-examination?
that's
future
my understanding.
cross-examination?
That was my understanding of what the request was.
That would seem to be a rather unusual procedure.
No, my recollection is that both sides have availed themselves of that several times in this trial. Mr. Cochran, what issue do you wish the court to determine before we call Dr. Reichardt?
Mr. Reichardt to leave before we do this courtroom?
What's the issue?
The issue, Your Honor, is as follows. I anticipate calling Dr. Christian Reichardt, who's present with his lawyer, Mr. Dominic Rubalcaba.
I see Mr. Rubalcaba in the back row.
Yes, he's injured today, but he's with us at any rate. Your Honor, I anticipate it'll be a very, very simple and direct examination. I expect that Dr. Reichardt will testify that he first met.
All right, I just want to know what the issue is.
The issue has to do with the scope of the direct and whether or not the prosecution is going to be able to bring up issues which aren't covered on the direct, and I'll be very right to the point.
Mr. Rubalcaba, can we have your client step outside, please? And I'll allow you to remain.
Thank you, Your Honor. In the course, and let me just, as an offer of proof, lay out what I expect the direct to be. It'll be very brief, and then you'll get an idea of where we'd like to limit any other examination will be beyond the scope. Dr. Reichardt, I believe, will testify that he met and became acquainted with Mr. Simpson sometime around the middle of 1993. Thereafter, they were friends. They knew each other over a period of time. In fact, in the earlier part of 1994, Dr. Reichardt was paid, I think, $5,000 for his work on the video in which he did some background and worked with Mr. Simpson about the perils of traveling, jet lag, drinking water, walking around the plane, things of that nature. He did a major script of 50 pages, reduced down to 5.
Was that the portion in the exercise video?
Yes, that was the resulting portion of that. And he had participated and helped out with that.
So
with
they
Mr. Simpson.
had a business relationship?
Yes, they had a business relationship, and he was paid for that over a period of time. That they continued to be friends. He was aware of Mr. Simpson's relationships. They talked that on June 12th, and specifically getting to the point we want to bring out, on the date of June 12th, 1994, Dr. Reichardt received a call from Mr. Simpson at about 9:00 p.m. that evening. Mr. Simpson was jovial, was his usual self with regard to his demeanor. They had a conversation at that time. During the conversation, Mr. Simpson talked about what he was doing with his life, that he was on his way to Chicago, and that they made basically a date. They wanted to get together on Wednesday of that week, which would have been Wednesday, June 15th, I believe. They made a dinner date or plans to get together when Mr. Simpson returned back from Chicago. That he will testify that Mr. Simpson didn't sound any differently than he has on other occasions. In fact, he sounded really upbeat and happy, and they had a very good conversation. And that's pretty much it. It'll be with regard to the conversation, the demeanor, the brief business relationship they had, that he was aware also of Mr. Simpson's personal life, who he was seeing at various times, and that's it. Now, I don't expect to go into any of these other incidents that occurred before that time. I don't expect to elicit anything regarding Faye Resnick and her drug treatment program or anything of that nature. I want to limit it just to these things, and I think the prosecution would be accordingly limited, and that's why I'm doing this now, so we'll have an understanding and move ahead.
Mr. Darden, any
It
response?
seems to me that he has something specific in mind, that is something specific he doesn't want me to go into, and perhaps we should ask Mr. Cochran what exactly that is. I mean, if we're talking about bias and prior business relationships and his attitude toward these proceedings and things like that, which are traditionally areas that are fair game and cross-examination, then of course I assume that I will be permitted to pursue those issues. I don't intend to ask about Faye Resnick and her
You do not.
and her drug usage. I mean, geez, we fought that issue, so why would I do that now?
I was kind of wondering that myself, but, things seem to change here from time to
Okay,
time.
sure. And nor will I ask him, this witness, about whether or not he's ever used drugs. Not that I'm saying that he has, but so what do we have in the 402 over?
Your Honor, this is someone from the side who asked for 402 on every hearing.
Well,
I'm just trying
counsel,
to narrow the issues, Your Honor.
Let me just explain something to you, just so we all know what the court's thought process is at this point. I would like for this jury to begin deliberations on this case sometime shortly after Labor Day, is my hope and expectation, which means that scope of examinations are going to get tightened and have been tightened. And if you recollect from the court's rulings yesterday regarding Mr. Regal, if there were scope problems, I enforced those restrictions. Now, attitudes and opinions, other issues regarding testifying, clearly that's under the evidence code and under Calgic 220. That's an area that Mr. Darden's entitled to go into. But it has to be impeachment that's relevant to the issue. And we know, since we've had these discussions informally before, we pretty much know what Dr. Reichardt is going to say.
Sorry, I didn't hear the last.
We pretty much know what Dr. Reichardt is likely to say at this point.
Yes, I do.
Okay.
And no one can accuse me of a lengthy cross-examination of any witness. I think I'm the only one in this
All right,
case.
well, then the more we talk about it, the longer this morning session's going to take.
Yeah.
All right, let's proceed.
All right, may I ask this one other thing, Your Honor? If there's an area of alleged impeachment regarding Dr. Reichardt, I would ask that the court, that either side, that certainly the prosecution approach the bench so we can argue it before it's asked, some question is asked improperly before the jury. That's been our general rule. Would that be the rule here also, Your Honor?
I'm sorry, I'm not going to ask any improper questions, Your Honor. But I will hand over any documentation I have just before I go into that area.
All right, thank you.
Now, Your Honor,
And Mr. Rubalcaba, do you want to come forward, be available to consult with your client?
Your Honor,
Have you been riding motorcycles?
yes. Perhaps a comfortable seat might be in order. He's here under in great stress and pain. Your Honor, may I then move on, given that, may I move on to the issue?
You want to
regarding
sit closer to you want to sit closer to the witness, or his seat? That's the bailiff's seat, so we'll need you over here. All right, thank you, Mr. Rubalcaba.
May I address also the issue regarding Howard Weitzman, Your Honor, so we can move right along?
Yes, sir.
All right, with regard to Mr. Weitzman, we expect, as I said, he'll be here around 10:30. This hearing would be, and we've talked about this also, so I think everybody is aware of this, we do not expect to get into any attorney-client communications. I do not expect, the court will recall that Mr. Weitzman had represented Mr. Simpson back on the 1989 incident. We're not getting into that. I'm not getting into any communications between Mr. Simpson and Mr. Weitzman from 89 to the present. That I don't want to get into any statements made by Mr. Weitzman publicly or privately or anybody in his family. These proceedings, Your Honor, the lawyers, that's all irrelevant. I expect only to go into his background briefly. He is a lawyer, that he was called on June 12th. The jury's already seen the video that go briefly into his background, June 13th, rather. He has a distinguished background, obviously, and I'll go through it briefly.
Well, Mr. Cochran, let me help you out here. What you're saying is you want me to enforce the scope objection regarding any cross-examination, and you want the court to be wary of any attorney-client issues. Is that
That's
what
exactly
you're,
correct. And I
all
want to go in, the issue I want to get to, right to what happened at the time of the statement and what he was told, and that's it.
And that's to impeach, this is
By
to
the tech-
impeach the
Detective
testimony
Van
of
Adder.
Detective Van Adder.
That's exactly correct. And I've told the court this before, and I want to make sure that everybody understands that.
All right.
I want to deal with that.
I'm sorry, who's going to be handling Mr. Weissman? Ms. Clark?
Well, I'd really like to know what counsel's talking about. What testimony is it that he's supposed to be impeaching? We have not entered a statement.
No, it has to do, I think, with the nature of the timing, location, and circumstances of Detective Van Adder talking to Mr. Weitzman, who was allowed to be present, who wasn't. There's apparently a factual dispute.
Your Honor, what difference does the factual dispute make if we have not introduced any evidence of the statement? We have not introduced one thing about the manner in which the statement was taken, the content of the statement, Mr. Simpson's demeanor, or any interaction with Mr. Weitzman. What is the relevance?
It's very relevant. Van Adder, and I'll show you the testimony of what Detective Van Adder said about who could be present during this statement. It's directly impeaching,
What?
and that's all.
All right.
I'd like to see the relevant transcript portions, Your
We'll be
Honor.
glad to show
I
it
do
to
not
you.
recall Detective Van Adder ever testifying
We have
to...
it. We'll be glad to show it to him.
All right, well, why don't you show it to her, and then what we will do is we'll proceed with recalling, oh, I'm sorry, Mr. Goldberg is back. We have Mr. Regal still present.
Right.
So let's have the offer of proof from Mr. Blasier as to the recalling of Mr. Regal. Let's get Regal out of the way, and then Dr. Reichardt. And then
Your
you
Honor, so
guys...
the court is clear on this Weitzman issue. We have Miranda waivers on tape from the defendant.
The issue goes to the attempt to impeach Detective Van Adder. Why don't you look at the transcript portion, and we'll take a look at it. Mr. Blasier, what's your offer
Good
regarding
morning, Your Honor.
recalling Mr. Regal?
Your Honor, after Mr. Regal was done testifying yesterday, he came off the witness stand. He had seen Detective Van Adder sitting in the back of the courtroom during his testimony, or in the back bench there. He put his hand out to shake his hand, and Detective Van Adder backed away and stated, "I'm not going to shake your hand. You are a traitor," or a word to that effect, or that substance. "You should be ashamed of yourself. I'm a cop. You're pathetic. I've been a cop for 27 years, and I've never seen a cop come in and testify the way you did." Now, we want to put Mr. Regal on to state that. It's directly relevant to the bias of Detective Van Adder, of his motives. It's state-of-mind evidence on Detective Van Adder as to his feeling that cops should not testify against cops. That's the central aspect of our defense, is the code of silence of the police department, and it's relevant to Detective Van Adder's credibility, and we wish to call Mr. Regal to demonstrate that. It's relevant to bias under Evidence Code Section 780. It's evidence of a habit and custom of the police department or Detective Van Adder of not wanting to say anything negative about another police officer.
Mr. Goldberg?
I'll handle this, Your Honor. This is ridiculous. I mean, we have really reached the most reaches I've ever seen. I'm actually speechless. I can't believe what I'm hearing. Detective Van Adder is entitled to his opinion. He is a human being and a citizen of this country, and he's entitled to his opinion. And if he wants to tell Mr. Regal, after he's completed his testimony, what he thinks of him, he's entitled to do so. And if Mr. Regal feels the need to go and cry to his lawyers about it, he can do that too. But none of it has anything that should be involving this court's time and attention and energy, which are already sorely taxed by a very difficult and lengthy case. This is absurd. These people want to put on everything they can think of, whether it's relevant or not, to slime the police department. I understand the motive. We've seen it in every case. This one is no different, just a slight bit more. It's more extreme. But to say that it's relevant, that Detective Van Adder voices an opinion of someone he feels to be unethical, he's entitled to do that, as am I. He did not try to dissuade the witness. The witness completed his testimony, went up to Detective Van Adder, and wanted to do the same thing that all these witnesses do. Excuse me for basically lying on the witness stand or saying things that I really don't believe in.
Wait. Ms. Clark, that's not called for.
I apologize, Your Honor.
That's not going to be tolerated. Why don't we have, wait,
Regal,
Ms. Clark, let's
Yes.
have an intelligent discussion here. Mr. Blasier raises the issue of bias and habit and custom. He raises two legal issues that you have not addressed. If you don't want to address those, then I'll assume those grounds to be well taken.
As to habit and custom, Your Honor, Mr. Regal went over to Detective Van Adder. He approached Detective Van Adder, not reverse. He was the one that sought out interaction with Detective Van Adder. He was the one who went and made the overture, wanted to say let bygones be bygones or whatever he wanted to say. Detective Van Adder gave him his opinion. There is no habit and custom shown here. There's no code of silence shown here. Detective Van Adder, if called to testify, would say that many of the statements made were misrepresented by Mr. Regal. And I can understand where there would be misunderstandings between two people when tempers flare. However, habit is more than one occasion, Your Honor. There's no habit shown here. There was one encounter that Mr. Regal didn't like that the attorneys wished to capitalize on. Habit has not been shown. As for bias, Detective Van Adder has an opinion of the witness's testimony. That doesn't reflect bias in terms of his relevance as a witness in this case. He has an interaction with someone who has completed his testimony. And the fact that a witness in a case has an opinion as to guilt or innocence, or has an opinion of a witness's credibility, does not make him biased as a witness in terms of giving his testimony. He's entitled to it. He's not on the jury, Your Honor. He does not have to withhold his opinion. And I don't understand how this could possibly be relevant to his bias, quote unquote, as a witness, when he testified, what, 6 months ago at this point? Detective Van Adder is entitled to have an opinion about someone else, to voice that opinion when the person approaches him to have an interaction without that being called habit and custom, code of silence, or bias as a witness. And if we have to, then we'll convene the mini-trial of Detective Van Adder and Larry Regal. Then we have to recall Detective Van Adder to set the record straight, say his true state of mind, which would make relevant his opinion of Mr. Regal's credibility and the nature of his testimony. That's what this would open up. Obviously, none of it's relevant. One witness's opinion of another's demeanor on the witness stand is their opinion. And when that witness approaches another and asks for the interaction, there's no reason why he can't voice that opinion. But to do so once certainly is not a habit or custom.
Detective Van Adder, when he testified, made many statements about the actions of other police officers, Detective Furman and others, in terms of what they did or what they did not do, whether things were done properly or improperly. His state of mind, as evidenced by his statement yesterday, is relevant, and that is that you don't say anything negative about another police officer, and that is directly relevant to his credibility, and we offer it for that purpose.
All right.
And the statements made were twisted to be offered for that purpose. As I understand it from Detective Van Adder, that is not what he meant or what he said. He simply offered his personal opinion of the witness's credibility and demeanor on the witness stand. Not, you don't criticize another police officer. It was rather, I'll tell the court what it was, you haven't investigated a crime scene in 20 years. How could you possibly know what you're talking about? I dare say there might be one or two others in this country that might share that opinion, but it certainly has nothing to do with a code of silence or habit and custom, Your Honor.
Now, then we always
I'm
have
concerned that both attorneys from both sides have referred to what other people around this country may think. That causes me to believe that the lawyers are pandering to the cameras, and that causes me to believe that probably I ought to pull the plug on the cameras. I'm contemplating doing that, so I'm tired of this kind of argument. All right. Any other comment?
No, Your Honor.
All right, I'm going to sustain the objection to the recall of the witness as to that issue for this reason. The probative value, since we have a dispute as to what that statement actually was, I find the probative value to be minimal. It will also prolong this trial by requiring the prosecution to recall Detective Van Adder to explain why it is that he holds this opinion, plus or pro or con, with regards to Mr. Regal, which will get into all sorts of inadmissible hearsay. And I think that given this isn't even remotely collateral, and I don't see any point in prolonging this trial. I think it's an undue expenditure of the court's time to engage in this kind of thing, so I'm not going to allow it.
May I inquire of the court, Your
All right,
Honor?
let's have Dr. Reichardt.
Because we haven't said, there's also another witness here from Chicago, Mr. Berris, Your Honor. And again, I want to just briefly take up with the court the issue and as an offer of proof. Mr. Berris is the officer we flew in last night from Chicago, who had responded to the hotel room at the Oak Park Hilton Hotel.
I recollect who he is.
About 11 o'clock, and he, along with some technicians from the Chicago Police Department, ultimately took possession of the knife, of a glass, the sharp glass, the
Towel.
shards of glass, the towel, etc.
I know
And then
who
they
he
were
is.
then transported. Then Looper, of course, took it up. I expect to ask him some questions, limiting it to just those things, not any other part of his investigation. And again, I'm just pointing it out to the court so we can have this same limit you've talked about with regard to cross-examination, that sort of thing.
what my cross-examination looks like. I intend to ask him about his observations of in the room. I don't know what is it that he's asking me to limit,
I think he doesn't want to go into the forest searches or any of that kind of stuff.
or means of escape from the hotel and all of that
I
good stuff.
suspect.
I don't know that. I would think that would be relevant.
I think not, Your Honor. That's the reason I'm making this motion at this point now,
Well-
to try to limit it so we can move through. Your court has just said we want to get this case to the jury by Labor Day. We concur and love to try to do that. We're trying to call these witnesses. I'm telling you up front what we're calling them for, and I'm trying to get some understanding of where we are. We can move ahead.
Problem being is we have a witness from, in this instance, a witness from Chicago that is not easily recalled. That's
Understand
our
that?
problem.
Well, what does that have to do with anything, Your Honor? If we are calling him, it's our case. You said we can try the case a certain way. You've said that 100 times. We're the ones who brought him out here. Mr. Simpson's the one who's
Well,
paying.
let's see where it goes. Let's see see how you lead him into this.
I'm already told you how I'm going to lead him into this, Your Honor, and I'm just trying to give the court a
But
heads
if
up
he's
on
there
this.
conducting an investigation in that room or at that hotel, it depends on what he was doing.
I indicated to the court he was there conducting an investigation into that room, and that's exactly the operative words, in that room. That's
All
the
right,
point I'm trying to
well,
get to, Your Honor.
That's what it sounds like to me.
Okay, and I need 5 minutes because he just got here this morning. I need 5 minutes. He would probably be the first one, and then Reichardt, and then Weitzman, the way things are going. The last thing, Your Honor, we do have the Menzione motion to the court. Care to hear that at some point before we get to
Well, I'd like to
Dr.
get to
Lee?
the jury and get some testimony under our belts.
That's fine. We'd like to get that under our belts also, Your Honor. I'd like just a few minutes to finish with those two witnesses. I'm ready to roll then.
Who's going to do Dr. Reichardt?
I am.
Are you ready with Dr. Reichardt?
I need.
I'd like to get Mr. Rubalcava on his way.
And I would like to do that also, Your Honor. Can the court give me 5 minutes for Reichardt and Berris to finish talking with him?
Before you leave the bench. As
You're-
it appears
you're
you're about
assuming-
to.
You're assuming I'm going to give him 10 minutes?
I don't think he needs the time, but Judge, before I was cut off, I wanted to inquire of you, now that the defense case is going to be prolonged a number of days, what day should we be prepared to have rebuttal witnesses appear?
Well, I mean, this tape motion, I mean, we're talking about 18 incidents and 30 other incidents,
No,
so,
that's 40. It's 40 and at least 18 or more.
you know,
Let me indicate to you.
so we're talking about individually, 50 or 60 individual rulings and arguments that I'm going to have to hear. This is going to be much like the domestic violence issue where we have to deal with dozens of issues, each of which is entitled to a separate ruling by the court, each of which the court has to weigh under 352. So you're talking about a significant argument and then time for me to think about it and sort it out. So, from the experience in the domestic violence issue, since you handled that argument, I assume it's going to be similar. So my guess is it will probably, that endeavor alone will take a couple days. Argument and then the court's analysis and ruling on the issue.
There's one difference out here. In this instance, we have tape recordings in addition to that you've previously ruled in January.
Well, I seem
So
to
we've
recollect
limited-
during domestic violence, we had tape recordings.
But we've limited, well, you had one tape, Your Honor. This instance, you have a ongoing tape recording of this person's voice, but you've also ruled in January. The proffer goes into the areas, only the areas. I mean, there's, 16 hours of tapes. So we've limited down to just the areas you've talked about that are relevant. So I just want to point that out. But whatever date you say, it's fine. What date?
No, Mr. Darden wants to know when he should start subpoenaing in his witnesses. My guess would be September 4 or 5th, actually, since that's after Labor Day. I don't see us resolving these issues and concluding the defense testimony before then, because we still have Dr. Lee.
May we approach?
All right, why don't you take your 15 minutes, 10
let me
o'clock.
approach him. Yeah, 10 o'clock, that's fine. We approach.
10 o'clock, all right. All right, back on the record in the Simpson matter, all parties are again present, jury is not present. All right, Deputy Magnaro, let's have the jurors, please.
regard to our discussion sidebar, the court, I think, indicate that perhaps the people should subpoena their witnesses around the 30th of August for rebuttal.
Yes,
Thank you.
thank you.
Your Honor, I think maybe the court is aware of the timing of this, that we filed our points and authorities in response to the initial proffer made by the defense. At the same time as we filed that, the defense filed points and authorities. What I wanted to ask the court is whether it would prefer that we file a response to those points and authorities, because obviously our papers couldn't be responsive, they were filed simultaneously, to the defense points and authorities, in writing or orally argue it.
Well, that's up to you, but if you're going to do it, you need to file it by Friday, close of business noon.
Okay. Okay. We will do our best to...
Because obviously this is going to consume my entire weekend.
Right. Right. Just to offer some ray of hope, because I personally am very upset about the extension of time of this case. I would, and I apologize to the court for losing my temper earlier this morning. The extended time and
Well,
delays...
isn't it amazing how much smoother things go when we address the specific issues?
I agree, Your Honor.
All right.
I'm certainly not arguing with the court. I'm apologizing to the court because...
Just an observation, not a criticism.
Yes, and I'm going to try and rein in my personal aggravation at things we can't help. But by...
We're all tired. All right, the record should reflect that we've been rejoined by all the members of our jury panel again. Good morning, ladies and gentlemen. All right, the defense may call their next witness, Mr. Cochran.
Thank you very kindly, Your Honor. We'll call Dr. Kristen Reichardt.
All right. Mr. Reichardt, would you come over here and stand by the court reporter, please, and face Mrs. Robertson, the clerk.
Raise your right hand, please. Do you solemnly swear that the testimony you give in the testimony before this court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat on the witness stand and state and spell your first and last names for the record.
All right, would you sit back and pull the microphone towards you, please? All right, thank you, Doctor. Mr. Cochran.
Good morning, ladies and gentlemen. Good morning, Dr. Reichardt.
Good morning.
Dr. Reichardt, what is your occupation, sir?
I'm a doctor of chiropractic.
And for how long have you been a doctor of chiropractic?
I graduated in 1983.
And where did you graduate from, sir?
National College of Chiropractic in Chicago.
And did you start to practice thereafter?
I practiced for 1 year in Chicago and then moved to California.
And are you presently in the active practice of chiropractic practice here in Southern California?
Yes, I am.
And where are your offices, sir?
I have an office in Malibu and another office in Santa Monica.
Now, I would like, sir, to direct your attention to the gentleman over to my left here, Mr. Orenthal James Simpson. Are you acquainted with him?
Yes, I sure am.
Will you tell the ladies and gentlemen of the jury when it was that you first met Mr. Simpson?
I met Mr. Simpson in the early summer of 1993.
All right, and thereafter, did the two of you become friends?
Yep,
And,
sure did.
and would you see him socially?
Absolutely.
All right. Did there come a time in 1994 that you had occasion to enter into some kind of a business relationship vis-a-vis a video that Mr. Simpson was to be in? Did that happen?
Yes, it did.
And when was that approximately?
Well, actually, in the later part of 93, we were talking about healthcare and exercises and so on and so forth, and an opportunity came up to do a video for Playboy magazine that was about jet lag and healthcare for the frequent flyer and frequent traveler.
And this was something that you and Mr. Simpson discussed, putting on a video to aid travelers with regard to jet lag and that sort of thing?
Yeah.
All right. What role did you play in helping to get this video ready and helping Mr. Simpson in that regard?
I wrote about a 60-page outline for him talking about nutrition and exercise and things that a traveler could do while they're on the plane, what to eat, what not to eat, things like that. We
So-
actually made also up a little exercise piece of equipment, a little rubber band that the traveler could take with him in his suitcase to be able to continue a workout program in his hotel room.
So you spent a number of hours on this project,
I'd say about 60, 65 hours.
and were you paid for your efforts?
I was paid in the moment when there was an agreement made that the Playboy will go ahead with the video, and then I was paid.
And how much were you paid?
I was paid $5,000.
So you did a number of hours for $5,000, is that correct?
Definitely more hours than I would have made the $5,000 in my practice.
All right. Now, with regard to that video, have you ever seen that video?
No, I haven't.
You never saw it afterwards?
Nope.
All right. But the part that you participated in had to do with how one would overcome jet lag and drink water and get up and walk around and things like that?
Right.
All right. Now, your relationship and friendship with Mr. Simpson, did it continue then in 1994?
Yes, it did.
And specifically, I'd like to ask you, on the date of Sunday, June 12th, 1994, did you receive a phone call from Mr. O.J. Simpson in the evening hours of that day?
Yes, I did.
And can you tell us approximately what time that call was?
That was about 9 o'clock in the evening.
9 o'clock p.m.?
Yeah.
All right, and tell us where you were when you received this call.
On the couch at home.
All right, were you alone at that point?
Yes, I was.
All right, and tell us what happened during that phone call.
OJ called to just check up on me and see how I was feeling because he knows.
Sustained.
Let me ask you some questions for my Honor. Mr. Simpson called, and you, of course, recognized his voice, did you not?
Absolutely.
And with regard to the tone of his voice, I want you to describe how Mr. Simpson's voice appeared during this conversation at 9 o'clock p.m. on Sunday evening, June 12th, 1994.
Or you can answer the question.
Okay.
You may answer.
He seemed a little bit more relaxed than in the recent months. He seemed very jovial.
All right. And you recall this specifically?
Yeah.
Did he seem downcast or sad at all during this conversation?
Not at all.
Well, I'm asking the question. Well, I can ask it another way.
Yes, you can.
Describe for the jury how O.J. Simpson seemed to you.
Hold on.
Attorney Young.
Yes, that answer is stricken, since I sustained the objection as being leading. Ask another
Thank you.
question.
Describe for this jury how Mr. O.J. Simpson seemed, how his voice seemed to you during this conversation at 9 o'clock on June 12th.
Yeah, like I said, he seemed more jovial. He seemed relaxed. He was packing his bag to go to Chicago. And we were talking about the fact that he's going to come
Okay,
back.
wait. Doctor, please listen very carefully to the question. It was just describe his tone of voice, not what he said.
Okay.
All right, juries to disregard the testimony regarding what was said. Mr. Cochran.
All right. So, anything else you can describe regarding his voice?
Just more relaxed than usual.
Okay. And how long did this conversation last?
I'd say about 15 minutes.
All right. So you talked about from about 9 until about 9:15?
Yeah.
And during this conversation, without telling us the substance of the conversation, did you and Mr. Simpson make any plans to get together later in that week?
Yeah, we talked about getting
No,
together.
that's not here, sir. You can answer yes or no, Your Honor.
Yes or no?
Yes.
All right, you made some plans?
Yeah.
And, Doctor, what date, if any, were you going to get together after that date?
Oral. You can answer the question.
The following Wednesday.
All right. And on the following Wednesday, which would be, I guess, Wednesday, June 15th, what were you and Mr. Simpson going to do?
We were going to go and have dinner.
Oral.
What were you going to do, sir?
We were going to go and have dinner
And that would have been where, in what city?
in L.A. He was going to come back and we were going to have dinner.
Now, with regard, you've described for this jury Mr. Simpson's voice of how he sounded, more relaxed and upbeat during this conversation. Did that voice ever change at all during this conversation?
No, it was a very friendly, very open, happy conversation.
It's a happy conversation? Is that yes?
Yeah.
Thank you very kindly, Dr. Reichardt.
Mr. Darden.
Can I have one moment?
Certainly.
Good morning, sir.
Good morning.
You consider yourself a close friend of the defendant's?
Yes, I would.
And you say you met him in early summer 1993, is that correct?
That's correct.
You consider yourself the defendant's best friend?
No.
You and he have gone to dinner on many occasions?
Yeah.
He's taken you to dinner? So you have to answer out loud.
Yes.
Okay. He's taken you on vacation?
Yes.
Took you to Cabo San Lucas?
Yes.
He paid for the trip?
Yes, he did.
Did he take you to Aspen?
Nope.
Take you anywhere else on any other vacation?
Nope.
When were you taken to Cabo San Lucas?
In Easter '94.
And how long were you there?
I was there for 4 days.
Okay, and that's down in Mexico?
That's correct.
You also knew Nicole?
Absolutely. I knew Nicole first.
I'm sorry?
I knew Nicole first.
She was also a close friend of yours?
I would say so, yeah.
Okay. When you told us that she had heard when you told us that the defendant sounded jovial and more relaxed than he had in several months. By the way, was that your testimony, that he
Yes.
sounded more relaxed than he had in several months?
Yeah.
And he hadn't been relaxed over the prior several months, is that correct? Is that correct?
Could you repeat the question?
Well, he hadn't seemed very particularly relaxed over the prior months, is that correct?
Yeah.
Is that correct?
That he seemed more relaxed that evening than previously?
Yes.
Yes.
And that's because during the weeks leading up to that phone call, the defendant had been depressed because of his failing relationship with Nicole Brown. Is that correct?
I wouldn't say depressed.
Well, have you ever described to anyone the defendant having been depressed?
At
Okay.
times, but he wasn't depressed all the time.
Well, during the weeks leading up to this phone call, did the defendant, in your opinion, seem depressed over his failing relationship with Nicole Brown?
At times, yes.
In fact, he seemed upset. He was upset with Nicole Brown during the weeks leading up to that phone call. Is that correct?
At times, yes.
And he was upset because Nicole Brown didn't want to see him any longer. Is that correct?
No, that's not correct.
You were interviewed by the LAPD on June 23, 1994. Is that correct?
Uh-huh, yeah.
You spoke with the officers about the defendant and his relationship with Nicole Brown?
Right.
Did you tell the officers that the defendant had been upset because Nicole Brown had changed her mind about having a relationship with him?
She changed her mind frequently about having a relationship with him or not having a relationship with him, and that's what he was upset about.
Now, please listen to my question carefully.
I am.
Okay. By the way, are you here to help the defendant?
Object to that question. I did testify.
Are you here to help the defendant?
Nope.
Did you tell the officers that the defendant was upset because Nicole had changed her mind about having a relationship with him?
I object to the phone records. I'd like to approach
It's been asked, that question was already asked and answered.
Well, it wasn't answered,
Let me see counsel sidebar with the court board, please. All right, thank you, counsel. Proceed. I think Mr. Darden was asking the question regarding the changing of the mind.
In fact, the defendant and Nicole Brown, they had an off and on relationship on a number of occasions. Is that correct?
That's correct.
Sometimes she broke up with him.
That's correct.
Sometimes he broke up with her.
Yep.
And it went like that for a couple of years. Isn't that right?
As the last year and a half that I was privy to, that's
The
correct.
defendant gave Nicole Brown an expensive gift for her birthday in May 1994. Is that correct?
Yeah.
And she returned that gift to him.
Yes, she did.
And he had given her some earrings on an earlier occasion. Is that right?
I don't know yet.
Sustained.
Do you know what date it was, the date that Nicole Brown decided finally that she would no longer have a relationship with the defendant?
I object to call that question simple fact, not evidence.
Sustained.
You told us a few moments ago that Nicole Brown was also your friend. Is that correct?
That's correct.
Is it your opinion, Dr. Reichardt, that Nicole Brown deserved to have had her throat cut?
Sustained. 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 It's not an appropriate question, Mr. Darden. Have a seat, Mr. Cochran. Not an appropriate question.
Can I be heard at sidebar with discovery, Your Honor?
Discovery? It's not an
There
appropriate
was a
question.
1054 submission to the court on that issue, as I recall.
With the court board. All right, thank you, counsel. Mr. Darden, you may continue.
Mr. Reichardt, Candace Garvey was a patient of yours, is that correct?
That's correct.
Okay, she is someone that you treated during the first week of July 1994.
Sustained.
Were you planning to somehow make some money off of this case, doctor?
Nope.
You were planning to write a book, weren't you?
That's correct. A book on personal ethics.
You were planning to write a book about Nicole Brown.
Nope.
You were planning to write a book about the defendant and Nicole Brown.
Nope.
You were planning to write a book about what you knew about the defendant's relationship with Nicole Brown.
Nope.
And you were planning to have a co-author on that book?
Excuse me?
Were you planning to have a co-author on that book?
Absolutely not.
Isn't it true that you told Candace Garvey that you were...
Overruled.
Isn't it true that you told Candace Garvey that you're going to do a book, write a book regarding Nicole Brown?
That's not correct.
Did you ever visit a lawyer, speak to a lawyer about writing a book?
Nope.
The first time that you were interviewed by the prosecution was what, June 23? I'm sorry, by LAPD was June 23, 1994?
Yeah, about a week and a half after the murder.
And had you prior to that agreed with someone else that you would not speak to the police regarding any information you had regarding the defendant and his relationship with Nicole Brown?
Overruled. Do you understand the question, doctor?
Could you repeat the question?
Okay. Well, had you and some other person agreed that you would not speak to the LAPD or the prosecution regarding any information you had regarding the defendant?
I had made an agreement to not talk to the media, but do whatever is required by the court.
Okay, so you had no agreement not to talk to the DA's office?
No.
You had no agreement not to talk to the LAPD?
No.
But didn't you tell Candace Garvey both of those things, that you had an agreement with someone else that you would not speak to the police or the DA's office?
Overruled. 770 and 1235, counsel.
I had an agreement to not talk to the
Could you please
media.
answer my question, yes or no?
No, wait. Let him finish answering the question.
Please, sir.
I had an agreement to not talk to the media.
So is the
That's
answer
it.
to my question no?
No, I did not have an agreement to not talk to the LAPD.
Now, the conversation you had with the defendant, the conversation you say you had the night of June 12th,
Mm-hmm.
okay, is that yes?
Yes.
Do you have a phone record to indicate the time of that phone call?
I don't have one. Mr. Simpson called me.
Okay, do you have a phone bill that'll indicate the time of that phone call?
I don't think it would show up on my phone bill.
Okay, do you have any record at all that will establish the time of that phone call?
I'm sure it could be established if Mr. Simpson's phone records would be checked.
Well, have you seen any record that will establish the time of that phone call?
No, I haven't.
Have you seen any record that will establish that that phone call ever took place?
No, I haven't.
You say you were alone in your home when you received this telephone call,
That's correct.
and you say it was approximately 9 o'clock.
That's correct.
Okay, you're not sure of the exact time?
About 9 o'clock.
Could be earlier, could be later.
Give or take a few minutes, because I looked at the clock.
You also looked at the clock.
Overruled.
You're also the defendant's chiropractor, is that right?
I've seen it as a friend, yeah, not a formal business arrangement.
Okay. You've treated him
Yes,
for free?
yeah, absolutely.
Now, this telephone call you say you received from the defendant about 9 o'clock that Sunday night, how long did the call last?
I'd say approximately 15 minutes.
15 minutes.
Mhm.
Is that what you told the LAPD when they interviewed you back on June 23?
I believe so.
Have you seen your statement?
Excuse me?
Have you seen your statement to the LAPD?
No, I have not.
And so you received this call and it seemed jovial and relaxed, more relaxed, right?
That's correct.
Had you spoken to him the day before at all?
No, I haven't.
How about the day before that?
No, I haven't.
The day before that?
No, I haven't.
Had you spoken to him at all during the 7 days prior to Nicole Brown's murder?
No, I haven't.
Okay. How about during the 2-week period prior to the murders? Had you spoken to
Yes.
the defendant?
I talked to him about 10 days prior.
And that was after the defendant broke up with Nicole Brown?
I think that was still at the time we were trying to figure out what to do.
And he seemed depressed and upset at that time.
He seemed upset at the time and he was going to go out of town.
Now, given the fact that you didn't speak to the defendant for another 10 days, you can't tell us then what his demeanor was like during that 10-day period leading up to that phone call. Is that correct?
No, I cannot.
And you can't tell us what the defendant's demeanor was after he hung up the telephone with you. Is that
No, I
correct?
cannot.
You can't tell us whether or not he was putting on an act or faking when he called you at approximately 9 o'clock.
Rephrase the question.
You understand that the defendant is an actor, correct?
Overruled? Overruled.
Yes, I do.
Has he had any formal training that you know of?
Not that I know of.
Have you ever discussed that issue with him?
No.
Can you tell us whether or not he was acting or putting on an act when you spoke to him on the telephone?
Can one ever?
Pardon?
Can one ever? How would I know?
Well, you know him.
Yeah, I mean, to me, he was not acting. Can I
To you, he
prove
wasn't
it?
acting.
Excuse me?
To you, he wasn't acting.
Nope.
So you can tell then.
Argumentative? Rephrase the question.
Would you agree that a person, a perfect stranger who didn't know the defendant before would have trouble telling if he was acting?
Mr. Stay.
You can't tell us whether or not the defendant was cut at 9:15 or 9 o'clock, can you?
You didn't see him physically on that date, did you?
No, I did not.
All right, that's the only testimony that's in the record, counsel.
Did the defendant tell you what he was wearing at the time?
Nope.
Overruled.
Tell you whether or not he had a pair of gloves with him at the time?
Overruled.
Now, you and the defendant, you plan to go into business together. Is that right?
That's not right.
Well, you had had a prototype of a certain exercise contraption made. Is that correct?
That's correct.
And what was this contraption called? Or did it have a name?
We hadn't given it a name yet. We're going to call it something like the Exerciser or something like that.
Or the Porta Gym or something like that?
Porta Gym. Yeah, it was like one of the names that we flew around. Yeah.
Okay, and when did you have that prototype made?
That was in February '94.
And you and the defendant had discussed producing this item, hadn't you?
Overruled.
If the video would be a success, then that was a possibility.
Okay, so my question is, you and the defendant had discussed producing this particular item, is that correct?
Possibly, yeah. We had discussed to possibly produce it item.
Will you possibly discuss something? You had possibly discussed?
No, we discussed to possibly produce the item.
Okay. You discussed producing the item prior to your having the prototype made, is that right?
Yeah.
Okay. And you did have the prototype made in February '94.
Mm-hmm.
Is
For
that
the
correct?
video. That's correct.
And you were going to include that exercise gadget or contraption with the video that you say that you and he were going to produce for Playboy. Is that correct?
We weren't the ones making that decision. Playboy would be the one making that decision.
Okay, but you were going to offer or suggest to Playboy that they include your exercise gadget along with the video?
That's correct.
Now, I take it you weren't going to give this exerciser to Playboy for free. Is that correct?
That's correct.
You and the defendant were going to manufacture these items, correct?
If Playboy would accept it, yeah.
Okay, and you were going to sell them to Playboy. Is that correct?
Yeah.
Now, in May and June of 1994, you and the defendant were planning to manufacture 100,000 units of this prototype. Is that correct?
Possibly. Yeah, if it would be included in the video.
Okay. Well, you were discussing the production of 100,000 of these units.
Yeah, not the defendant and I, actually the person that helped me manufacture it, yes.
Okay. But you and the defendant were discussing the production of these as well, correct?
Yeah, but not of 100,000 pieces.
The defendant was going to kick in some money into the project?
No,
You never discussed with the defendant him putting up money
Nope.
for this project?
no. I was going to put up money.
You were going to put up the money to produce 100,000 units.
Yes.
And you had that kind of money.
Sustained.
Did you have that kind of money, sir?
Sustained.
We wouldn't have made up.
Sustained.
Okay.
Well, have you produced this item?
No.
In fact, you were talking to someone about producing this item all the way up to the last week before Nicole Brown's murder. Is that correct?
Probably, yeah.
You were speaking to someone about producing this item up until the defendant's arrest, correct?
I don't recall.
But close to that day.
Probably.
Okay. But you
But-
haven't discussed it with that person since the defendant's arrest, have you?
I've thought about it, yeah.
You've thought about it,
Absolutely.
but you haven't discussed it with the person who produced.
Nope.
So the project is no longer viable. That is, without the defendant. Is that correct?
Overall. But we are going about at the end of it.
Okay. When you spoke to the defendant that night, he asked you about Nicole, didn't he?
Actually, no.
The defendant didn't ask you if you heard from Nicole?
Overall.
Did the defendant ask you during that telephone conversation if you had heard from Nicole?
I don't believe so.
Let me show you a copy of a statement.
Have you shown this to Mr. Cochran?
Mr. Cochran has a copy of it.
Mr. Darden, I want you to
Page 2, paragraph.
show also Mr. Rubikov if you have an extra copy. Counsel, why don't you step over to the podium here, confer with each other, and then show Mr. Rubikava, please.
Let me show you a copy of a statement prepared by the LAPD where it contains your comments to them on June 23, 1994. I'd ask you to look at paragraph 2, page 2.
Yeah.
All right, witness nodding affirmatively. Mr. Darden.
Does that refresh your recollection, sir?
Yeah, I mean, obviously the focus of the conversation was not about the call, so
Okay. Well,
I'm,
did the defendant ask you during that phone conversation whether or not you'd heard from Nicole Brown?
I don't recall right now, but as it is there in the paper, probably did.
But you don't recall now.
No.
By the way, let me ask you to read this statement. And let me ask you if anywhere in the statement did you tell the LAPD that the conversation lasted 15 minutes?
I'm checking the phone that question.
Overruled. Overruled.
And your question was, could you repeat it again?
Does the statement indicate that you told the police that you spoke to the defendant for 15 minutes?
Nope. Overruled. Overruled.
I object to the speaking objection. Did you read the complete statement, by the way?
Did I ever read no, I never
sorry, I'm
received
asking-
a statement.
My question is, did you read this complete statement just now? Did you
I
read it?
glanced over it, yeah.
Okay, you feel like you're familiar with what's contained therein? I mean, you have a grasp of it?
Yeah.
Okay,
Kind
seems accurate to you?
In order to be accurate, I'd have to read it more in detail. I just trying to see whether somewhere it said I talked to him for 15 minutes.
After the defendant and Nicole Brown broke up, did the defendant tell you that he was concerned that she was seeing someone else?
Yeah.
Overruled.
Yeah.
And this was during that time period in which he was upset and depressed, is that right?
Overruled.
Is that correct?
I don't. Could you repeat the question?
This is during that same time period in which the defendant was both upset and depressed at having broken up with Nicole.
Yeah.
And this will be during the end of May, is that correct?
That's correct.
At about the same time that she returned the jewelry to him, correct?
I don't know exactly when she returned the jewelry to him.
Do you know what the defendant did with the bracelet after Nicole Brown gave it to him?
Sustained.
I have no idea.
That's all I need.
Mr. Cochran.
Dr. Reichardt, Mr. Darden asked you some questions, and he didn't finish asking the questions about the statement. Have you ever first...
Excuse me, counsel.
Well,
Let's
let me...
rephrase that.
Okay, I'll rephrase it. With regard to this alleged statement that was reported by the Los Angeles Police Department on June 13th, 1994, from June 13th, 1994, do you recall talking to the police at some time after June 13th?
Yes, I do.
And were you cooperative when you talked to them?
Absolutely, yeah.
All right. And in that statement to the police, you told them that about this conversation with Mr. O.J. Simpson, isn't that correct?
Yes, that's right.
You told them that Mr. Simpson was packing for his trip to Chicago, that he'd return on Wednesday, isn't that correct?
That's correct.
Just like you told this jury, right?
Right.
And that they would get together when he returned,
That's correct.
just like you told this jury, right?
Absolutely.
Do you...
You could just ask him about his testimony or about the statement, but what he's doing in front of the jury's here to observe that.
Thank you, Your Honor. Now, do you recall in this conversation whether or not this police officer, by the way, was that a telephone conversation that you had with the LAPD? The conversation over the phone?
I mean,
No,
phone
that was-
interview.
Was it a phone interview?
They came to my office.
Okay. And you sat and talked with them, right?
Absolutely,
All
yeah.
right. Do you recall them ever asking you how long your conversation with Mr. O.J. Simpson was?
Nope,
All right.
I don't recall.
But as you sit here now, you recall how long that was, don't you?
Absolutely.
It was 15 minutes?
Yeah,
And if they had asked you, you would have told them 15 minutes, right?
absolutely.
Now, with regard to the statement about whether or not you talked about Miss Nicole Brown Simpson, that was not the thrust of any of that conversation, was it?
Not at all.
In fact, do you recall that Mr. Simpson had said that to you that he was out of the loop, that he was glad to be out of the loop, and that he had gotten his life together with his new lady? Remember him telling you that?
That's correct.
And who was that new lady?
Paula Barbieri?
And you knew about Paula Barbieri, isn't that correct?
Yes, I did.
Also, Mr. Simpson had told you that he began dating Paula Barbieri on a regular basis, isn't that correct?
Yeah,
And that you had said and indicated to the police in the interview that Mr. Simpson seemed to like Paula a lot and seemed happy, or at least happier than he'd been before once he was with Paula. Isn't that
that's correct. Yeah,
And that's what you told the police, isn't that correct?
yeah,
And when you talked to the police, Dr. Reichardt, were you telling them the truth?
absolutely.
And you're coming here today to testify to this jury. Are you telling them the truth?
Absolutely.
Now, Mr. Darden asked you some questions about treating Mr. Simpson, and you said yes, you did. You recall that?
Yeah.
And what did you treat Mr. Simpson for?
Well,
You open the door. What did you treat him for?
for his knee problems,
And what knee problems are those?
I observed him one day in the morning walking down the stairs, and that he had
He can answer. Please.
that he had a very hard time walking, and I said, "Come on, and we'll start taking care of that."
And when was that?
It must have been also early summer '93,
And how long did you take care of him for his knee problems?
sporadically when he was in town.
And did that continue on into 1994?
Absolutely, yeah.
Mr. Darden asked you about writing a book. Do you have any plans? Have you ever tried to profit one iota on this case, sir?
I refused to.
And every time the district attorney's office has asked you to come down and talk with them, you've talked with them. Is that correct?
That's correct.
In fact, you did a rather lengthy interview with Mr. Darden himself. Isn't that correct?
That's right.
At some point. Is that right?
Yeah.
You came down voluntarily and talked to him?
He came to Mr. Rubalcava's office.
And you talked to him?
Yeah.
With regard to these trips, you and Mr. Simpson were friends. Is that correct?
That's correct.
And you've been on various trips together?
That's correct.
Been out dinner together?
That's correct.
And back in 1993, when you first had occasion to meet Mr. O.J. Simpson, at that time, was he seeing Miss Nicole Brown Simpson at the point? Were they together?
They were trying to see whether it would work out or not.
And who was pursuing who at that point, if you recall?
At that time, Nicole was trying to put a family together.
Overruled. She was trying to get back with him?
Right, to have a family for her children.
Just a moment, Your Honor. Dr. Reichardt, when you would go on trips with Mr. Simpson, you'd pay your own way, would you not?
Yeah,
All right.
at times.
All right. And would sometimes Mr. Simpson provide lodging or rent a house or a villa for everyone?
That's correct.
And you'd pay your own way to get there?
For the plane tickets, yeah.
You'd pay your own? All right.
and food and things like that.
Now, with regard to your knowledge of Mr. Cole Brown Simpson and Mrs. Simpson, you've described for us that Mr. Darden asked you a question about at some point they stopped seeing each other and that Mr. Simpson started seeing Paula Barberi. You recall that?
Yeah.
And,
Excuse me. Overruled.
and was there a time when you were aware of, was there ever an argument where Mr. Cole Brown Simpson called you up and argued with you about after she'd broken up with Mr. Simpson, or they had broken up?
Yes, there was.
It had to do with your going. Oh, he's
Sustained.
opened the door yet.
Not to a statement by somebody else.
Well, I didn't ask the statement. I didn't ask the statement yet. May I ask another question?
Proceed.
Thank you, Your Honor. Was there an occasion when Mr. Simpson started to date Paula Barberi that Mr. Cole Brown Simpson became upset and there was a that you received a telephone call from her?
Sustained. That's your statement. Wait, that's also a speaking objection. You're not standing either, counsel. Sustained.
Thank you. I have nothing further at this point, Chairman. Thank you very much.
Thank you, Mr.
Thank you,
Carter.
Doctor.
Your Honor.
Recross, Mr. Darden.
Thank you, Your Honor. Mr. Reichardt, was the defendant dating Nicole and Paula at the same time?
I don't believe so.
Do you know that for a fact?
I don't know that for a fact.
Now, in talking to you about Nicole Brown, isn't it true that on many occasions that you and the defendant would often talk about the problems the defendant was having with Nicole Brown?
Sustained. It's vague.
Okay. Well, you and the defendant would go out on occasion, right?
That's correct.
And on those occasions, you and he would talk about your respective relationships, correct?
Overruled.
Correct?
That's correct.
And he would talk to you about his relationship with Nicole Brown, is that correct?
That's correct.
And he told you how hard he had been trying to make Nicole Brown happy, is that correct?
Overruled. Overruled.
He told you how hard he had been trying to make Nicole Brown happy, is that correct?
That's correct.
And he told you that she wasn't happy in that relationship, didn't he?
At times, yeah.
In fact, this was a recurring theme in conversations you had with the defendant, wasn't it?
That's correct.
Overruled.
Now, you told us a moment ago that you treated the defendant for his knee. Is that correct?
That's right.
Okay, you're not a medical doctor.
No, I'm not.
You saw the defendant and you felt he had a problem with his knee.
It was pretty obvious, yeah.
Okay. But you didn't stop him from doing that exercise video in late May 1994, did you?
Nope. Overruled.
Were you present during the shooting of that video?
No, I wasn't.
Overruled.
You weren't present at that video shooting to make sure the defendant didn't injure himself?
He's already indicated he wasn't there.
No, I wasn't there.
Did you ask to be there so that you could...
Sustained. Sustained.
Are you, strike that. Do you know a woman named Gretchen Stockdale?
Overruled.
I don't believe so.
Okay. Were you ever introduced by the defendant to a woman who was a lingerie model for Victoria's Secret?
Sustained. Sustained.
Okay. To the best of your knowledge, was the defendant seeing anyone else during May 1994, that is, other than Nicole Brown and Paula Barbieri?
Overruled.
Can you repeat the question?
Was the defendant seeing anyone else, any other woman, during May 1994, in addition to Paula Barbieri or Nicole Brown Simpson?
Not that I know of.
Thank you.
Dr. Reichardt, there were occasions when you and your lady friend would go out and double date with Nicole Brown Simpson and Mr. Simpson, is that correct?
That's correct.
And on occasions, and who was your girlfriend?
Faye Resnick?
And on occasion, would you talk, would the four of you talk about domestic matters?
Absolutely.
All right. And on occasions, as I understand what you've told this jury, as with all couples, there were times when Miss Nicole Brown Simpson wanted to get back with the family, right?
That's correct.
And and there were times when Mr. Simpson wanted to get back, is that correct?
That's correct.
And they tried to get together and make it, is that correct?
Yeah,
And they didn't make it, isn't that correct?
they didn't make it.
And after they didn't make it, you became aware that Mr. Simpson was seeing Paula Barbieri, isn't that correct?
That's correct.
And he seemed happy and more relaxed, right?
That's right.
That's what you told us here today, right?
Yeah.
Thank you, sir. Thank you for coming. Nothing further.
You also told us that Nicole Brown cut that relationship off, didn't she?
That's not
It was Nicole Brown Simpson that left the defendant and not the other way around. Isn't that correct? Isn't that correct, Dr. Reichardt?
I think they went through difficult times and they...
Dr. Reichardt, isn't that correct?
He can answer the question.
It was Nicole Brown Simpson that broke up with the defendant, correct?
Overruled. Just answer the question, Doctor.
I don't think it's a question that could be answered with yes or no.
Thank you.
And after that occasion, after that occurred, the defendant was depressed and he was upset about it, right?
I think at the time when they both mutually figured out that it's not going to work, yeah, they both were depressed.
Anything more, Mr. Darden?
Dr. Reichardt, kind of unusual that after a 17 or 18-year relationship finally ended, that both of the parties might feel a little bit down. What is it, doctor, psychology?
Overruled.
Your Honor, that's speaking.
Overruled.
Did you find that unusual?
I don't find that unusual at all.
In fact, you find that quite normal, doctor?
They have 2 children and yeah, I find it quite normal.
Thank you, doctor.
Do you profess to be some doctor of love now, Dr. Reichardt?
Sustained, sustained. Counsel, we have to remember that we have an intelligent jury here.
Okay.
They have common sense with human experiences.
I'd like to ask the witness about a psychological term, may I?
You may.
Have you ever heard of estrangement rage theory?
Nope.
Never read about that?
Nope.
Thank you.
All right, doctor, thank you very much.
You're welcome.
All right, your excuse. Mr. Rubalcaba, thank you, sir. All right, next witness.
Yes, Your Honor.
Let me just inquire, anybody need a comfort break? All right, while you're getting your next witness, we'll just excuse Juror quickly. All right, let me see, counsel, look for reporter, please. The court with his counsel, the people are represented, the jury is not present. We also have counsel Mr. Weitzman and Mr. Tarlow present. Mr. Cochran, you had something to bring to the court's attention?
Yes, I do, Your Honor. Good morning again, Your Honor. We have had, during this break, an opportunity to talk to Mr. Weitzman, who's come here today, and I thank him and his counsel, Mr. Tarlow, for doing that. He is willing to testify. We've conferred with Your Honor and actually with Mr. Simpson. And we've decided at this point not to call Mr. Weitzman. He's available to testify if we need him. We don't think it's necessary at this point, and if it becomes necessary later, he will come back. And we thank him for coming.
We'll know where to find him.
Well, yes, I think we can now find him, yes.
Okay.
And he
Your
was-
Honor, we have the subpoena quashed, and he'll be available through either his office or mine.
Yeah,
Well,
that's fine
upon your
with us.
representation, counsel, that you'll make him available upon reasonable notice, I'll accept that.
That'll be fine. Thank you.
Thank you, Judge.
And thank you, gentlemen, for coming. We're ready with the next witness will be Mr. Berris, Your Honor.
All right,
Whenever
then
you're
I
ready.
would suggest we take our recess for the lunch hour then, at this point.
That's fine.
All right, you had a,
One other question. With regard to the Menzione, the court knows that we'll have Berris, then we would like to resolve the matter of Menzione before Dr. Lee testifies because it'll be determinative of whether we have her come out. So at some point, you're going to let us argue that. Ms. Sean Chapman will argue that.
all right, I'll be delighted to hear the argument.
Remember, we're this close. You recall that.
I recall
All right.
that.
Just let us know when to do that, Judge. Thank you.
All right, I anticipate doing that sometime this afternoon then. I understand that. All right, anything else before we stand in recess? Did you want to take care of that one other issue?
Oh, yes, Mr. Klein.
Mr. Douglas?
Yeah, Mr. Douglas would like to approach and do it at sidebar, if at all possible. I'll have him step in though first. That'll be fine.
So, Your Honor, just so I can go over the next witness that's after Marcia will be Mr. Berris, and then we will go, excuse me, wait a second. So then we have a couple of issues to argue with respect to
I understand that. All right, Mr. Douglas is also present with Mr. Klein Allen, who was present and ordered back to return today. Mr. Douglas, what's your pleasure?
I'd like to push on information.
All right, with the court board, please.
And Joe.
All right, counsel, as far as the court session is concerned, we'll stand in recess until 1:30. Mr. Allen, I'm going to ask you to remain to consult with counsel for a few moments, all right, after we've cleared for the day. Excuse me, for the morning. All right, we'll reconvene at 1:30. All right, I'll be in chambers, counsel. Jury is not present. Mr. Darden, are you going to handle Mr. Lee, or is Mr. Goldberg?
Who's next? Mr. Berris.
Mr. Berris, all right.
I'm going to handle Mr. Berris.
All right.
Way down the elevator.
I'm sorry? You ready? All right, Deputy Magnaro, let's have...
I'd like to approach just in one matter again. This is important.
What is that?
One matter I'd like to
Right. What do we have to do at the sidebar? We don't have a jury.
Yes.
With the court reporter.
I saw that.
All right, Deputy Magnaro, let's have the juror, please. Gentlemen, please be seated. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good afternoon, ladies and gentlemen. And Mr. Cochran, you may call your next witness.
Thank you very kindly, Your Honor. Good afternoon, ladies and gentlemen. We'll next be calling Detective Ken Berris to the stand. Detective Berris?
Raise your right hand, please. You do solemnly swear that the testimony you may give in the cause now pending before this court should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please have a seat in the witness stand and state and spell your first and last name for the record.
All right, why don't you pull the microphone close to you? There you go. Thank you.
Yes, my name is Kenneth Berris. My last name is spelled Berris.
Good afternoon, Mr. Berris.
Good afternoon.
And what is your occupation, sir?
I'm a detective assigned to Area 5 Detective Division, Chicago Police Department.
And how long have you been so employed, sir?
I've been a police officer over 26 years and a detective over 18 years.
In that connection, have you come here today to be with us here in California pursuant to subpoena issued by this court?
Yes, sir, I am.
And you arrived in Los Angeles when?
Last night.
First time you and I have had an occasion to talk was when?
Earlier today, this morning.
All right, I'd like, sir, to direct your attention back to the date of Monday, June 13th of 1994. Do you recall that date?
Yes, sir, I do.
At some time in the morning hours of June 13th, were you assigned some duties in connection with the O'Hare Plaza Hotel in Chicago, Illinois?
Yes, I was.
Approximately what time did you get a call, or were you assigned some particular duty?
At approximately 11 o'clock in the morning on that date, myself and Detective Anthony Bongiorno, if
You
you'd
might
like,
spell
I'll
that-
spell his
you spell
last
that
name.
for us?
Please.
Of course. Bongiorno. He's also assigned to Area 5 Detective Division, where I am also assigned. We were assigned to go to the O'Hare Plaza Hotel by Sergeant Vernis Jones, a supervising sergeant in our unit.
All right. And thereafter, after you and Detective Bongiorno were assigned to this particular hotel, what time, if you recall, did you arrive at the O'Hare Plaza Hotel?
We arrived shortly after 12 noon.
And is that, would I be correct in assuming that that hotel is near the airport in Chicago?
Yes, it's nearby.
All right. And when you arrived there at the hotel around 12 noon, did you have occasion to go and speak with a general manager at that hotel?
Yes, we did.
Without telling us the conversation at that point, tell us the name of that general manager, sir.
Mr. Peter Phillips.
All right. And did you and your partner officer have occasion to talk to Peter Phillips?
Yes, we did.
All right. And how long did that conversation last, sir?
Oh, approximately half an hour.
All right. And during the course of that conversation, did you obtain some information about a room 915 in the O'Hare Plaza Hotel? You can answer that yes or no.
Yes, we did.
And were you able to ascertain whether or not that room had been secured that morning prior to your arrival?
Yes, it had been.
All right. And thereafter, at some point, did you and your partner have occasion to go up to room 915?
Yes, Detective Bongiorno and I, accompanied by Mr. Phillips, went to room 915.
And when you got there, did you have a key to that room?
Mr. Phillips had a key.
All right. And so when you describe for the jury what kind of a key did you have for that particular room?
It was a what I might refer to as a card key. It's put into a slot. It's a card coded, and it's put into a slot, and the code unlocks the door.
All right. And are those the kind of doors that have some kind of little computer in them?
Yes, I think that would be a fair description.
Let me see if I can give a word picture. You slide the little card into it, and the little green light comes on. Push the handle, and the door opens up. Is that right?
Yes.
All right. So that's what happened with Mr. Phillips. Is that correct?
Yes.
And what time was that when you did that?
I would approximate that to be between 1:30 and 1:45 in the afternoon.
Now, with regard to that particular room, did you ever have occasion to check to see whether or not there was, in fact, a computer that would tell the number of times anyone had entered that room on June 13th, 1994?
I never determined anything like that there was such a computer as part of the locking device.
Okay. At any rate, you gained entrance in there sometime around 1:30 to 1:45.
Yes, sir.
And who went inside the room at that time, if anyone?
Myself, Detective Bongiorno, and Mr. Phillips.
All right. At that time, sir, did you have occasion to look around and look inside the room?
Yes, we visually inspected the room.
Okay. And how long would you say you stayed in the room at that time?
Oh, approximately 20 minutes or so.
All right. Did you pick anything up at that time at all?
No.
All right. You just had a visual observation of the room. Is that correct?
Yes, sir.
And would I be correct in assuming that there was no one in that room at that point?
No, when we arrived, there was nobody in the room.
And with regard to the bed in the room, did the bed appear as though someone had slept in that bed the night before?
Yes, the bed wasn't made. The covers were tossed back as if someone had been sleeping in the bed.
All right. And so the bed hadn't been made by the maids at that point. Is that correct, sir? The best you could tell?
I'm sorry, I don't...
I said the bed had not been made by...
Oh, it had not been made. That's
Okay.
correct.
All right. Now, you told us that you stayed in there approximately a half hour, and then did there come a time when you then left and went someplace else to make a phone call?
Yes, the three of us, myself, Detective Bongiorno, and Mr. Phillips, left the room, or mini suite of rooms, if you will. The room was secured and locked, and we then went to Mr. Phillips' office, where I called our crime lab, the Chicago Police Department crime lab, and requested crime lab technicians to come to that location.
All right. And about what time was this now, sir?
I made that call between 2 and 2:15, I would estimate.
All right. And you requested some crime lab technicians.
Yes.
And did there come a time when the crime lab technicians arrived at the hotel?
Yes.
And approximately what time was that?
3 o'clock in the afternoon.
So by 3 o'clock then on June 13th, 1994, the crime lab technicians arrived. And tell the jury their names, sir, please.
Crime lab technicians John Stella, S-T-E-L-L-A, and crime lab technician John Naujokis, N-A-U-J-O-K-A-S. They responded to their location.
All right. And who went back up to room 915, if anyone at that point?
Myself, Detective Bongiorno, the two crime lab technicians, and Mr. Phillips.
All right, sir. Now, I want you to just describe generally for the jury in brief fashion how this room was laid out, the hotel room. Can you do that for us?
Yes. Room 915 could be described as actually a mini suite of rooms, if you will. It consists of a living dining area combination. Uh, After passing through a doorway, you would be in the bedroom of the suite, and then passing through another doorway, you would be in the bathroom of the suite.
All right. When the first time when you were there with Mr. Phillips, did you ever go in the bedroom the first time?
Oh yes, we had gone into all of the rooms.
And the bathroom also, is that right?
Yes, sir.
All right. When you went back this second time with Najokas and Stella, the criminalist, was Mr. Phillips accompanying you at that point?
Yes, he was.
All right.
However, he did stay in the living dining area with Detective Bongiorno.
All right. So there were like 5 of you, is that correct?
Yes, sir.
All right. And when you went back in, you've described for the jury this particular room. At some point, I think you've described for us the bed appeared as though it was unmade still. Is that correct?
Yes.
All right. And then you had occasion, did you not, to go into the bathroom area, that suite of rooms. Is that correct?
Yes, sir.
And in that bathroom area, did you have occasion to see? Let me seek to rephrase that, Your Honor. Okay. In the bathroom area, can you describe for the jury what, if anything, you saw in the sink of the bathroom area there of Suite 915?
In the basin of the sink was a broken drinking glass. It was a clear glass that was broken and in the base of the sink,
All right.
along with a paper doily that those are usually on top of the glass when they're in the room.
Okay. And this glass was inside in the sink in the basin area, right?
In the basin.
Did you see any other remnants or shards of this glass on the so-called vanity area in and around the sink?
Yes, there were at different locations along the vanity several small, and I'll describe them as chips because they were very small, of broken glass.
All right. And now what about towels? Did you see any large towels in this same general area near the sink basin area?
Yes, on atop the vanity, directly to the right of the wash basin, was a towel that was not folded. It appeared to have been used. It was wrinkled and left on top of the vanity to the right of the basin.
And did you have occasion to lift that towel up at some point?
I didn't.
Did the technicians lift that towel up at some point?
Yes, when in the course of their processing that scene.
And when the towel was lifted up, did you have occasion to see a washcloth or a face cloth?
Yes, I did.
Describe for the jury what you saw with regard to this washcloth or face cloth.
That washcloth had a reddish stain on it, which I suspected to be blood.
All right, and you saw, describe for us how you saw that washcloth or face cloth.
It was, it was underneath the towel. It's the best I could describe it, to the right of the sink bowl. When I initially had gone into the bathroom, I didn't see it since the towel was on top of it, concealing it from view.
All right, so would I be correct, Detective Berris, you couldn't see the smaller face cloth until the towel was lifted up by the technicians, is that correct?
That's correct.
All right. Now, with regard to the things you've just described for our jury, were there photographs taken of that bathroom area and the sink area, which might be illustrative of what you've just talked about?
Yes, there were photographs taken of the entire
Okay.
mini-suite.
Thank you. I want to show you. And I'd like to show these to counsel. I'd like to show them, witness a couple of these, if I might, then I'll
Proceed.
on the Elmo, if I might. I want to show you what's first been marked. I think we marked these starting with 1331. Let's see. I want to place before you several photographs. Mr. Darden has seen these. I want to place before you defendants 1331. And I want you to describe what's depicted in 1331, sir.
That is a photograph of the washcloth with the red stain on it, which was suspect blood, that was found to the right of the wash basin in the bathroom of that mini suite of rooms.
And is that a fair and accurate portrayal of the way that that washcloth appeared after it was removed, after the towel on top of it was removed?
Yes, sir.
All right, then I'd like to place this on the Elmo, if I might.
You may.
I'm going to place the others before him also.
All right, this is 1331.
This is 1331, Your Honor. Thank you. And I'd like also to have Mr. Sheriff do that too. We've blown up 1331, we have a 1331A also.
Is that- I think we need to clear the PowerPoint there. Be overruled.
Now, while Mr. Harris is moving 1331A in position, that's the way that particular face cloth looked after the towel had been on top of it had been moved. Is that correct, sir?
Yes, sir.
And you've seen 1331A also, have you not? The large photograph of that?
Are we still speaking of the washcloth, Mr. Harkin?
Have you seen this 1331A? It's a
Oh, the
blow-up
large,
of
the
that.
large poster, yes.
Yes.
Yes, I have.
And 1331A is a blow-up of the photograph on the Elmo. Is that correct, sir?
Yes, sir.
All right, sir. I might now, Your Honor, I'd like to ask you in turn about the other photographs. Will you look at 1332 and tell us what's depicted in 1332?
In that photograph, it's a photograph of the wash basin and vanity of the bathroom in room 915. And you can, it depicts in the basin the broken drinking glass and white doily cover. And atop the vanity to the right is the wrinkled towel, which was there upon our inspection.
And is that the towel you described for us earlier that had it covered the face cloth?
Yes, sir.
All right. I'll place this on the Elmo. It's 1332, Your Honor. So, 1332 is a fair and accurate portrayal of the way the towel, the large towel looked while it covered the smaller face cloth depicted in Defendant's 1331. Is that correct?
Yes, sir.
Would it be better to describe that as a hand towel? Doesn't appear to be a bath towel size.
You're talking about the larger?
Yes.
I think that's fine, Your Honor. We call that a hand towel then?
I was just referring to it as a towel myself.
Well, the judge says call it a hand towel. I think we generally call it a hand towel.
I agree.
Let's call it a hand towel then.
Yes, sir.
Well, they give you three kinds of towels in a hotel. They give you washcloths, hand towels, and bath towels. These are experts on hotel towels.
And apparently so are you, so I'll go along with it.
And they know about those locks, too.
Okay. Thanks, Judge. Okay, with regard to, let's move quickly through this then. The hand towel was covering the face cloth, is that right?
Yes, sir.
Okay, and to the left of that is the glass you described, the broken glass that's in the face basin, is that correct?
Yes, it is.
I want to put 1331 back up for just a moment and ask you a question. You had mentioned that there were some chips of glass, and I want you to look at 1331 and point out to us, if you can, whether you can see some chip of glass to the left of, upper left of this particular face cloth.
Yes, that's one of the chips of glass that was on top of the vanity, yes.
You described that for us earlier.
Yes, sir.
All right, and that's basically to the left and above the basin, is that correct?
Yes, sir.
Okay. And moving along then, with regard to 1333, what's depicted in 1333?
That is a photograph of the wash basin in the bathroom of room 915 with the broken drinking glass inside the basin with the white doily cover.
All right, there's a doily, and the doily's fairly well depicted in there.
Yes, sir.
In 1333. Put this up quickly.